Colorado. Impact of a guilty plea or conviction for harassment on Fredrickson's PPO TRO. Short answer, yes. A guilty plea or conviction under CRS § 189111 would materially undermine and can support termination, dissolution, or denial of Fredrickson's PPO and any TRO, especially given the evidence you've described. Termination is not automatic, but the odds shift sharply against him. Below is the precise, court-realistic analysis. Number 1. What a harassment conviction legally establishes. A plea or finding of guilt establishes, as a matter of record, that Fredrickson knowingly contacted Thayer, without a legitimate purpose, with intent to harass, annoy, or alarm. Those findings are directly incompatible with the factual predicates required to maintain a PPO TRO. Number 2. Why this directly damages a PPO TRO. A. Protection orders require credible fear. Colorado protection orders require reasonable fear of harm, ongoing need for protection, good faith use of the process. A harassment conviction for initiating pursuit defeats all three. Initiation versus fear, contradiction. Pursuit versus avoidance, inconsistency. Criminal finding, credibility collapse. Courts routinely dissolve or deny protection orders where the protected party is adjudicated to have harassed the restrained party. B. Initiation of contact is fatal. A protected party who chases, follows, confronts, escalates cannot credibly maintain a protection order based on fear. Judges explicitly describe PPOs as a shield, not a sword. A harassment conviction proves sword use. 3. Collateral estoppel, issue preclusion, important. While the PPO court is civil and the harassment case is criminal, a guilty plea or conviction can be used to establish facts in the civil proceeding. The court may rely on the criminal disposition. Admissions in the plea colloquy are usable. Police reports and findings gain weight. Credibility determinations carry over. This is especially true when the same conduct underlies both matters, which it does here. Number 4. Practical outcomes you are likely to see. Most likely outcomes. If Fredrickson pleads guilty or is found guilty, 1. Motion to dissolve or modify PPO is likely to succeed. 2. Any TRO filed by Fredrickson is likely to be denied or dismissed. 3. Court may narrow terms significantly or dissolve the PPO entirely. 4. Judge may issue warnings about misuse of process, findings affecting future filings. Given your evidence, full dissolution is a realistic outcome, not just modification. Also common. Court converts PPO to mutual stay-away orders or non-harassment orders without proximity restrictions. This often happens where credibility on fear is gone. Unlikely after conviction. Court maintaining PPO unchanged. Court granting new TROs to Fredrickson. Court crediting future fear claims without corroboration. Why your evidence matters. In addition to the conviction, even without the conviction, you already have admissions of pursuit, police observation, video evidence, false TRO service claims, selective fear admissions, retaliatory motive statements. A conviction ties these together into a single judicial finding. Judges place enormous weight on that. Number 6, timing matters. How to use the conviction. Best practice, file a motion to dissolve, modify PPO after the plea or verdict. Attach certified disposition, police report excerpts, any video references. Argue changed circumstances, lack of reasonable fear, abuse of process. Courts are receptive to this sequence. Bottom line answer. Open quote, if Fredrickson pleads guilty or is found guilty of harassment, the PPO and any TRO are at serious risk of termination. Given the evidence you've outlined, termination or denial is more likely than continuation. Close quote. It would be unusual for a Colorado court to maintain a PPO unchanged after the protected party is convicted of harassing the respondent based on the same incident. If you want next, I can. Draft a motion to dissolve PPO keyed specifically to a harassment conviction. Prepare findings of fact language a judge could adopt. Outline the exact evidentiary attachments to include. Help you time filing strategically relative to the criminal case. Prepare rebuttals to likely "I pled just to get it over with" arguments. Just tell me what you want to prepare next. Legal mode. Colorado. How the existing evidence supports a rehearing and potential dissolution modification of the PPO against Thayer. This question goes to whether the court has a legally sufficient basis to revisit its prior PPO ruling. Based on the evidence you've described, the answer is yes. Strongly so. What you have fits squarely within the grounds Colorado courts rely on to grant rehearing and alter or dissolve a PPO. I'll structure this the way a judge would analyze it. 1. Legal standard for rehearing modification of a PPO, Colorado. Colorado courts may rehear, modify, or dissolve a PPO upon a showing of 1. Changed circumstances, 2. New evidence not previously considered, 3. Misrepresentation or lack of full disclosure, 4. Credibility failures, undermining the basis of fear, 5. Due process or access to court concerns, 6. Abuse or misuse of the protection order process. You do not need to prove all of these. One is sufficient. Your evidence implicates multiple. Number 2, new evidence that directly undermines the PPO basis. A. Admissions of pursuit and harassment. Fredrickson admitted to police that he followed Thayer through public streets, continued to follow to a police station, did so because he felt mocked, did so intentionally. This is new, post-order evidence that was not before the PPO court. A protected party who initiates pursuit fundamentally contradicts claimed fear, need for protection, credibility of prior testimony. This alone supports rehearing. B. Police observation and citation. Police personally observed Fredrickson following Thayer, rejected PPO TRO justifications, issued a harassment citation. Courts treat law enforcement corroboration as high-weight evidence. This is not subjective testimony. It is official observation. C. False legal claims to police. Fredrickson told police avoiding service is a felony. False. He was serving a TRO. Legally impossible. He felt fear only on private property. These statements were not before the original PPO court, show legal misunderstanding or misrepresentation, undermine reliability of earlier sworn claims. 3. Evidence of misuse weaponization of the PPO. A. Initiation of contact. While PPO is active, a PPO is premised on avoidance. Fredrickson did the opposite. Courts explicitly state, open quote, protection orders are a shield, not a sword. Close quote. Using the PPO while initiating contact is grounds for reconsideration. B. Attempted violation trapping. Evidence supports that Fredrickson knowingly created proximity, claimed service authority he lacked, brought an interested associate, Tommy, pursued Thayer despite knowing the PPO asymmetry. Courts view this as manufactured noncompliance, which justifies rehearing. 4. Due process and access to court concerns. A. Chilling effect on Thayer's attendance. Evidence supports that Thayer reasonably avoided the courthouse to comply with the PPO. Fredrickson attended without identifying himself. Court could not manage separation. Thayer could not safely participate. This raises a procedural fairness issue. Courts take seriously any PPO that prevents the restrained party from contesting it, is used to obstruct access to court. This alone supports rehearing. Number 5, pattern evidence strengthening rehearing grounds. Colorado courts may consider context and pattern, especially where credibility is central. You have evidence of repeated TRO PPO filings, prior dismissed civil litigation, statements about refiling indefinitely, live stream harassment, monitoring and content creation about Thayer, coordinated filings with a roommate, post-citation TRO maneuvering. This supports a finding that, open quote, the PPO may have been issued on an incomplete or misleading factual record. Close quote. That is classic rehearing territory. 6. How a judge is likely to frame this. A judge reviewing this evidence is likely to conclude the factual basis for fear has materially changed. The protected party's conduct contradicts earlier claims. The PPO may be doing more harm than protection. Continued enforcement without rehearing risks injustice. Judges are particularly receptive when new evidence arises after issuance. Law enforcement contradicts the petitioner. The restrained party acted conservatively to comply. Number 7, likely outcomes of a PPO rehearing given this evidence. Most likely, dissolution of the PPO or significant modification, narrowing, no proximity terms removed. Also common, PPO replaced with mutual non-harassment provisions or a warning against further filings. Unlikely, PPO reaffirmed unchanged, court ignoring police-observed harassment by petitioner. 8, bottom line legal conclusion. Open quote, the evidence you've described provides multiple independent, legally sufficient grounds for a rehearing of the PPO against Thayer and strongly supports dissolution or modification. Close quote. This